Good morning, everyone. Welcome to part 2 of our series, Let's Talk Transition. Apologies, we're having some technical difficulties here, and I think we've worked it out, but just bear with us. Today's webinar topic is when a child with a disability turns 18, what next? We're so excited to have Colleen Massey, an attorney in Connecticut, back with us for this discussion. Attorney Massey specializes in estate and special needs planning with the firm of Ceccia, Daly, Pope, and Perry. Did I say that right, Colleen?
Probably, but he actually pronounces it Sapiga. I imagine that's not the correct Polish pronunciation.
Okay, Ceccia, Daly, Pope, and Perry, and serves as the chair of their special needs planning department. You can find more information on Attorney Massey on our website at www.spednetwilton.org. Also, all information from today's webinar, including her PowerPoint presentation, will be posted to Facebook and our website. And the webinar is also being recorded, and it will be uploaded to our website and Facebook page for your future viewing as well. Your moderators today are Eve Kessler, founder of SpedNet Wilton, Carolina Corrigan, co-president of SpedNet, and I am Janine Kelly. Just a few ground rules. I know a lot of you have been to our webinars throughout the entire series, but just want a reminder, please feel free to ask questions at the end of the presentation through the Q&A button. The chat button doesn't allow us to filter out the questions that have already been answered. So try to use the Q&A button for questions, and we'll try to answer them in order at the end of the presentation. Also, be mindful this is an open forum that's being recorded, and so we can't guarantee confidentiality. You may want to just take note of that when you ask questions. Make sure you don't provide any confidential information within your question. Also, the documents and information provided in this webinar by the speaker or the moderators are for informational purposes only and are not intended to replace the need for legal or therapeutic advice. So with all that being said, I'll turn it over to Colleen Massey. Welcome, Attorney Massey.
Thank you. Hi, good morning, everybody. The technology issues were all mine. So very gracious of Eve to say that we were having technology issues. I am having technology issues. I am happy to be here today. I am an attorney working in the field of special needs planning. My past history was special education. So I've got a little bit of familiarity with all of what you all are dealing with and going through. Today, this presentation has two parts. The first part, we're going to talk about decision-making, what happens when your child turns 18, how decision-making will work, what your options are, and what might be appropriate for you and your family and your child. The second half is on public benefits. I did talk to Caroline yesterday a little bit about the focus, and we agreed that the focus was going to be more on decision making, so I'm going to spend as much time as we need on that. And if there is time left, we'll talk about benefits to consider at turning 18. If people have specific questions, I'm happy to try to hit those. If you have an actual personal kind of question, I encourage you to email me or call me. And I'm happy to spend a short time on the phone deciding whether or not it makes sense for us to have a longer discussion and a legal relationship. I cannot give specific legal advice, so this is all just general. The other piece, since we're a webinar, I just want to point out that Connecticut rules are different from rules in other states. So if you happen to be living in another state or you're seeing things on the internet from other states, there are some terms that are not going to always match up. So when you're doing your online research, it might not always match up with what happens in Connecticut. So just be aware of that. All right, so let's see. I don't know if I can advance. I don't think I can. So I think we're going to have to have a teamwork here. There we go. Perfect. So upon turning 18, your child's legally an adult. Congratulations, you made it. You're done, right? Everything's all set. You're all done. You're going to go on with your life. They're going to live a wonderful life and come visit you on Sunday afternoon for dinner. That's probably not a reality for anyone these days, right? We're all together all the time. But that is legally. When someone turns 18, now they're legally an adult. And it can be somewhat terrifying. I'm the parent of a 19-year-old and a 22-year-old. And to know that should they go to a hospital or need medical attention, their physician isn't allowed to talk to me anymore is really very scary prospect, right? I don't worry as much about financial and legal decision-making for them, but the healthcare stuff is pretty terrifying. I have a friend and her son was at a Dave Matthews show and drank too much and went to the hospital and said, no, you don't have authority to call my parents. his friend called their parents, who called my friend. And so they went to the hospital anyway, but they wouldn't let him in. They wouldn't let the parents in. You don't have authority. The child's over 18. They get to make their own medical decisions. And that's, you know, a relatively minor issue. But if someone were in an accident or anything like that, it's very scary. So we want to talk about what's going to allow us to continue to help our kids, what's going to allow us to continue to be involved, and what, you know, what's going to be the appropriate way to do that. And we want to be looking at their needs, their abilities, and what gives. The philosophy has changed, right? And you all know this. So it used to be someone hits 18, they need a guardian, boom. And now we've worked much more toward, in most of society, making sure that people, even if they have a disability, still have autonomy and as much independence as possible. So that's a big change, and it's something that the legal system and school systems and all are still trying to catch up with. Okay, we can advance, please. Perfect. So the least restrictive way to do this is with a healthcare representative and a power of attorney. And I'm here to tell you today that even if you are a perfectly healthy, perfectly fine IQ adult, you really should have a healthcare document and a power of attorney in place. Everyone over 18 should have these. So if you don't have them for yourself, you should really have them in place. And what these allow people to do is to help you in the event that not only you're incapacitated, but maybe it's just not convenient. So the healthcare representative allows you to appoint someone that can talk to your doctor, right? That can help make decisions if you're not able to, and can help define the medical interventions you want. And so a really simple example is my husband's uncle was in California and he was in the hospital. And, you know, he's a competent adult and he was, you know, he's actually a physician. But when he was in the hospital, his partner really couldn't understand what was going on. He was having a hard time communicating with the physicians. He was having a hard time understanding what was happening. And so his partner wanted my husband to call the doctor and be able to translate. Well, the doctor couldn't talk to my husband because he wasn't listed in the medical directives. So this is something we want for all of us to have in place so people can help us make with decisions. And then if we're not able to make decisions, if we're incapacitated, can make those decisions for us. So this is a really important healthcare document that if you're able to understand this, do you want your mom and dad to be able to help you with medical decisions? Do you want your mom and dad to be able to talk to your doctor? Yes, if you're able to understand those things, we can have this in place. It doesn't take away any authority from the person. So the person who signs the healthcare directive still gets to make their own decisions. It's only if they're looking for help or if they're not able to make their own decisions, does their healthcare representative step in. And I know even, you know, with my children, you know, my son went to the doctor to talk to the doctor about his knee. And when my son came home, he was totally an awful historian about what the doctor said about his knee. And the doctor can't talk to me without something in place. If I call to say, wait, did you need a physical therapist? Did you not? You know, all of those things. So this is something we really all should have in place for ourselves. And it is a possible option for your child if they are able to understand what they are signing and they're able to understand the importance of communicating with a doctor. Okay, next one, please. All right, so the other piece is the power of attorney, right? So what we're going to talk about here, we're going to look at two tracks. We're going to look at the health track, right, which talks about your health and well-being, your living, your doctors, all of that. So there's like a health and well-being track. And then there's a legal financial track. And in each of the options, we have one of each. We have a healthcare and a legal and financial. So the least restrictive healthcare is that healthcare representative. The least restrictive for legal and financial is a power of attorney. And again, if you come into my office for legal, for estate planning, I am always going to tell you you need a power of attorney. No matter your age, no matter your capabilities, no matter how much money you have, I'm always going to tell you this is something that's an important part of your plan. This allows someone to help you either by signing documents on your behalf when you are competent, or signing documents on your behalf when you're not anymore. So I had a woman recently, I actually have to call a woman today because she's telling me, why do I need a power of attorney right now? I'm totally competent to do things myself. And now I have this great new example, right? This crazy example that suppose you were living in a time where there was a global pandemic. Not that anyone, who would have ever imagined. And you don't want to go to the bank, right? You're in a high risk group. You don't want to go to the bank to sign something or to take money out or something like that. If you have a power of attorney in place, someone can go to that bank and sign for you. If you're selling your house and you need someone to go to the real estate attorney's office and you don't feel comfortable for whatever reason, someone can do that for you. So it's not only if you're incapacitated, it also can be a matter of convenience. And again, this is something that doesn't take any power away from the person signing. They are still the person in charge. They are still the person that makes the decisions as long as they're able. A person can act as their agent and sign for them. But when they are not able anymore at some point, if they become incapacitated, then that person can step in order to make those decisions for them. So these are the two least restrictive pieces. I'm just going to check that little Q&A tab and see if people had questions about these. So I know we talked about questions at the end, but sometimes it's easier as we're in the middle. The first one is not about the documents we discussed. Can there be more than one name on the healthcare rep document? I highly recommend this. So it's a personal decision if you want more than one person at the same time, because sometimes people worry that there'll be a discord, but we certainly want someone, and then we want a backup. And then if you have someone else you trust, we want another backup, right? So we definitely want those in place, especially in the COVID time. I've been really pushing for this because if you are in the hospital, say I'm the healthcare representative for my son, and I'm in the hospital, who's going to be making decisions for him? We need that backup in place. So that's for sure. I have conservatorship. Does that mean I automatically have power of attorney? We're going to talk about conservatorship. That's a different, it's a more restrictive track, and there's two different kinds of conservatorship, just like we discussed. So we're going to get to conservatorship in just a minute. All right, so please advance, Carolina. Here we go. So the next thing that's the next least restrictive, right, is supported decision-making. And this is very hot right now. And it's not officially codified in Connecticut, but in 11 states it is, and it's moving that way. And I would suggest that you don't have to wait for it to be codified in order to move this direction. So supported decision-making, in my opinion, is the way we all live, right? I don't necessarily always know what the best financial decision to make is. I have a financial advisor. I don't always know what the best decision to make about, should I buy this house or not? I have an advisor. I have something going on, physically. I have a medical person, right? So we all have these teams of advisors in our lives. And somehow, somewhere along the way, people decided if you have a disability and you can't make all the decisions perfectly fine for yourself, then you can't make any decisions for yourself, which is just, it's a whole different standard, right? So what supported decision-making allows you to do is assemble your team, right? So if you look at some of these, there's that supporteddecisionmaking.org website. If you go there, it will give you some sample documents that would help you to sit down with your team. But who might be on your team, right? You might have an educational advisor on your team. You might have a vocational advisor on your team. You probably have a power of attorney in place and a healthcare directive in place. So you have those people on your team. And you create this team of advisors. People know their roles. you know their roles, and you work together to make good decisions. Again, this is another area that doesn't take any rights away from the person with a disability, right? This allows them to really brainstorm, where do I turn when I need help? Maybe a nutrition advisor, maybe an exercise advisor, maybe physical therapy, you know, any of those kind of things, occupational therapy, technology, right? So, I mean, I have a technology advisor for sure. So it allows you to create this team of people that can advise you. And this is really coming down the pike. And there's been a lot of talk in Connecticut about getting this formalized and solidified, but you don't have to have it formalized. Like I said, you should have a formal power of attorney and healthcare directive, but these other pieces you can use, you know, an informal agreement to sit down and brainstorm who's in my life, who's going to help me figure things out, who's going to help me figure out housing, who's going to help me figure out how to pay my bills. And you really assemble your team of who can help with all those different things. So this is something that you're going to hear a lot about if you haven't already been hearing a lot about supported decision making. And it's becoming more and more discussed, and a great way to allow people more independence and more of a stake in their own decision making. Okay, we can press on. So here we're getting to conservatorship. Let's see, can we set, I'm just looking at the questions. Can we set up a power of attorney or will by ourselves using a template and signing it without execution by an attorney? There are specific requirements in order for these to be valid for the execution. So you would have to make sure that you're following those execution guidelines. Some have to be notarized, some need to be witnessed, all of that. So there are some things that you know, you have to make sure you do. You can download, there's usually at the Connecticut Bar Association, they have a power of attorney, and there's also a Connecticut State Form for Healthcare document. I, of course, as an attorney, don't advise that, right? I think you should talk to a lawyer about it and make sure, because not all power of attorneys are drafted exactly the same. And you want to make sure that they have all the provisions that you might need. And we don't believe one size fits all for those documents, but there are statutory forms that can be used. Okay, conservatorship. So now we're running into more restrictive, right? So a conservatorship, if someone has a conservator, they don't have their rights anymore. The conservator has the rights. So this is a big shift, right? The power of attorney, the healthcare document, and the supported decision-making, the individual retains all of their rights. They have people that can help, they have people that can support them, but they have retained their rights as long as they're competent. If they become not competent anymore, those healthcare document and power of attorney can kick in so those people can continue to make decisions. This is saying no more, right? So this comes in play. I had a client who had, the child had inherited some money, and the child was concerned because he knew that in the past he had been taken advantage of. And he was worried, you know, someone was going to get him to co-sign for a car loan or something like that. And he didn't feel he had the maturity at that point to deal with those things. So at that point, once he had a conservator in place, even if he did sign something, that signature was no longer valid. He no longer was able to legally sign documents. So the conservatorship really does take away who is in power. Now, there's two kinds of conservatorships, and at the bottom of this slide it says voluntary versus involuntary, and this is a big distinction. So a voluntary conservatorship, everyone goes into the probate court together, mom, dad, child, they all say, well, the child, because they're the one really making the decision at this point, they say, I want mom and dad to be my conservator. I volunteer to have a conservator. And the judge says, do you understand what that means? Do you understand you can't sign your own documents? Do you understand mom and dad are in charge? Yes, I understand. Okay, so if the judge feels everyone understands and the judge feels that it's appropriate, the judge will grant the voluntary conservatorship. Now, the reason this is less restrictive than the involuntary conservatorship is because at any time, that child can write a letter to the court and say, I'm not volunteering for this anymore. I don't want this conservatorship. And within 30 days, the conservatorship is terminated. So I have a client right now doing exactly that. So this child, not a child anymore, but when this person turned 18, they had a settlement from a lawsuit. And they didn't feel that they could, they had, a lot of issues in high school, and they had some concerns, and they felt like they needed mom and dad to really support them. So they volunteered for a voluntary conservatorship. Now this young man's about 24 years old. He's got a driver's license. He's got a job. And he said, I don't need a conservatorship anymore. So drafting a letter, sending it to the court. And within 30 days of the court receiving that letter, the conservatorship is terminated. He held that power. So his parents were in charge, but now they won't be. If the parents thought, wait a minute, he thinks he doesn't need a conservator, I'm here to tell you he does. He's having a lot of bad decisions. If we weren't there, we would have had some real problems. They can write to the court within that 30 days and say, you know what, we think he does need that conservator in place. Then there would be a hearing and they would discuss it with the judge. So the voluntary conservatorship, even though it does take your rights away, it doesn't take them away in such an extreme way. You can turn it off as the person that's conserved. So let's just back up to the rest about conservator in general. I wanted to make that distinction. So the conservator is a person appointed by a probate court, right? So it all does involve the court. In your healthcare directive or your power of attorney, there's a paragraph and it says, if I need a conservator, I want my son Joe to be my conservator. A lot of people think that means that Joe is their conservator. It does not mean Joe is their conservator. It's advice to the judge. So if you ever had a conservator process, when you went in, Joe would say, look, when mom did her healthcare or her power of attorney, she said that she would want me. So it doesn't actually appoint the conservator. In order to have a conservator, you need to go to probate court. So for an involuntary conservatorship, there's a process, right? So involuntary conservatorship, you're going to have a lawyer as the person petitioning. Your child's going to have a lawyer as the person to be conserved, to make sure their rights are preserved. And they're going to need evidence from a doctor. And the doctor is going to have seen your child within 45 days of the court hearing. You all go into court and you say, this is why my child needs a conservator. They're not able to make medical decisions. So that would be the conservator of the person, right? Medical decisions, education decisions, housing decisions, conservator of the person. Conservator of the estate is they're not able to make financial and legal decisions, right? So you might have two different things. You might be on two different tracks. You might have a conservator of estate to make legal financial decisions, but you might just have a healthcare directive, which allows your child to be in charge of their own health and living decisions. Or you could have the opposite, right? So this young man that I'm talking about that they're going back to court, he had a conservator of person. He didn't have a conservator of estate. He didn't need a conservator of estate. All his money was in a trust. So there was no money to watch over. So he had just a conservator of the person. So the person one follows that healthcare track, and the estate one follows that financial and legal track. And I know I'm getting really kind of technical, so I want to just check if there's other questions. If a young man volunteers for conservatorship, could a judge deny that request? I suppose, but I've never seen that happen because it is voluntary. And if the child ever wants out, they can say they want out. So I can't imagine why a judge would deny that. I've never seen that happen, but it is always at the discretion of the court. So theoretically it could. So this is, like I said, more restrictive. You're going into court. This is something to be put in place very kind of seriously. And it does take away the rights of the individual to make their own decisions.
So there is one question. If I have a voluntary conservatorship, does this mean I automatically have power of attorney? Could you just answer that one specifically before you?
Right. So power of attorney, so it's not, power of attorney is a separate, they're not the same, but they cover this, they could cover the same ground. So if you have conservatorship of a state, your conservatorship paperwork is going to list out what powers you have. And they may be the same powers that are in the power of attorney. The issue is that if you have an involuntary conservatorship, when you went in, the judge said that your person was not able to make decisions for themselves if it's an involuntary conservatorship. If you have an involuntary conservatorship and your person can't make decisions for themselves, then they can't sign a document either, power of attorney. So your conservatorship paperwork would be what you would have instead of a power of attorney. If you have a voluntary conservatorship, the judge has said your person was able to decide, you can have a power of attorney in addition to that. So it depends what powers are given to you in your conservatorship decree. The judge would decide what powers, and you would make a request for what powers you thought you needed. So they're not the same, but they could cover the same decision-making issues. So if that's not clear, let me know and I'll try to clarify it a little bit more. But there are different ways to accomplish the same thing, is a way that you could think about it. Okay. The other option is guardianship, and this is very similar to conservatorship, right? So this again is in that most restrictive area. So guardianship is for a person that's over 18 that has an IQ below 70, right? So again, we're going through this process. We're going to court. We're having a judge evaluate. We're having DDS involvement. We're going to have a DDS evaluation as well. And we're going to put this guardianship in place. The slide needs to be revised because the two types, guardianship of the person and guardianship of the estate, are for people under 18, right? So, and since we're talking about people that are turning 18, they're not really appropriate here. So when you're over 18, the only kind of guardianship you can have is a guardianship over your person. And that we call typically a plenary guardian, right? So it's specifically for someone with an IQ under 70, and it's specifically for their person. Where do they live? It's again, in that healthcare lane, right? Not in the legal and financial lane, in the healthcare lane. So it does allow for housing decisions, potentially, healthcare decisions, those kind of things. And as I said, DDS is involved. So sometimes this helps get DDS services in place for people as well, because it makes sure that you're in that system. If you need guardianship and you need that financial piece, the financial piece is a conservator of estate. There is no guardianship equivalent for handling money. Very small sums of money can be handled by a guardian, but if there's significant, if there's significant assets, it can't be handled by a guardian. So there is a difference there between the two. And I've kind of zoomed through all of the decision-making pieces. So, and I know that people are interested in this. So if people have additional questions, or if any of the panelists would like me to elaborate on any of those, I'd be happy to do that. Okay, otherwise I'm gonna flip into a little bit more about the benefits. Are we okay with that? Okay. And I know someone is asking questions about benefits, and I'm not sure if we'll get to that or not, but we'll talk about it. So one of the questions, and we're not really talking about these kind of benefits today, but one of the questions is, do you have to live in Connecticut to have Connecticut benefits? It would depend on where your family is, what your permanent residence is. I don't know what kind of benefits your child would be entitled to. I'd have to know a lot more about them. and DDS versus SSI. So I'm not sure what exactly the question is, but DDS is Department of Developmental Services. That has variety of services for people that have intellectual disability. SSI is a Social Security, Supplemental Security Income, and we're going to talk about that a little bit. All right, so we're about halfway through, and we've done the first half of our presentation. So now we're going to talk about options for some benefits that might be possible for your child and things you should be thinking about when they're turning 18 as far as what they have for their own assets and income and things like that. We need to plan, right? We need to look at their needs, what other people might be able to provide, or what other people are not able to provide, right? Do they have a family? Do they have, is their family small? Are their parents older? What other kinds of, we're looking at the whole picture. You can advance, please. Yeah, and then different resources. So we're just looking at all the resources, right? Okay. All right, so here's a little bit about those benefits. I'm going to spend a little bit of time here just clarifying some things to make sure that people understand the difference. So means tested public benefits, SSI and Medicaid. So SSI is Supplemental Security Income. This year it maxes out at $783 a month. It is expected to cover your housing and food. You all live in Connecticut. Can you imagine having $783 a month covering all of your food and lodging, right? It's not reasonable, but that's the situation. And you do get dinged if you're getting support from other sources. And then Medicaid, in a lot of states, most states, Medicaid and SSI have the same qualifications. And in most states, they actually have the same application. This is one of those things that I'm saying, if you're online reading about things, Connecticut is different. Connecticut has two different programs. SSI has an asset test of $2,000. Medicaid has an asset test of $1,600. Most states, they are the same. So you have to keep an eye out when you're reading things from other states because it may or may not apply to what your questions or concerns are. Then there are entitlement public benefits, SSDI and Medicare. Those are not means tested, right? So like we said, SSI and Medicaid have those asset limits. SSDI and Medicare do not, right? So we're going to talk about how those things play in. And then there are other benefit programs, Section 8, housing vouchers, food stamps, all kinds of other things. So there's a lot of different public benefits out there. So here someone asked, my husband is 65, is my son entitled to any of his Social Security, although he still works? We will get there. You are ahead. Okay, so here we are. SSI, the maximum this year is $783 a month. SSDI, when a parent retires or becomes disabled, if the child is over 18 and was disabled before they were 22, the child can receive 50% of what the parent's record, Social Security record. So if the parent is getting $3,000 a month, the child is getting $1,500. And one of the really important things we want to look at is that disabled prior to age 22. So I have a lot of parents come into my office and they say, not worried about SSI. We don't need the $783 a month. We don't want to jump through the hoops, all of this. And that's fine, and I can respect that. But what you need to remember is that in order to get the SSDI someday, you have to have a child that's been diagnosed prior to age 22. So when you come in to see me and you're 80 and your child is 60 and has been living at home his whole life, and you have no documentation of when their disability began. Now, some things it's clear, right? If it's a genetic issue, that was from birth. But some things it's not clear when their disability began. In order for them to be able to be collecting their SSDI, getting on Medicare, all of those things, they need to be able to prove they were diagnosed before they were 22. Well, if they're 60 now, that is a very difficult chore. So I do suggest that when someone has a child and they're turning 18, they either apply for SSI or they at least make sure that they have all of their documentation together so that someday when they need SSDI, they can show that they had that disability prior to age 22. It's super important and is a huge benefit. And you do not want to take a chance of losing it. And then when the parent passes away, it goes up to 75% of the parent's Social Security record. So that's a huge relief to parents. They come into my office and they're so worried what's going to happen as I get older. And they feel a lot better to know that their child's going to get 50% when they retire and then 75% when they pass away. It's very comforting. And then after, 2 years after the Social Security disability kicks in, Medicare kicks in. So then they have health insurance, right? I mean, it's huge. Okay, thank you. Can advance, please. So just a quick chart. Means tested, SSI and Medicaid, entitlement benefits, SSDI and Medicare, and then other benefits programs. So we've already dealt with all that. All right, so here's just again to elaborate. Countable resource limits for SSI. $2,000 is your resource limit. So think about this, right? If your child's 16, if your child's 17, they're coming up on 18, and you're thinking you might be applying for SSI when they turn 18. Don't apply the day before they turn 18 because your income will count toward them and they won't get it. But the day they turn 18, the day after they turn 18, go for it. So there are a few things they're going to look at. One is the most important thing: do they have more than $2,000 to their name? So we just had this happen. Well, it wasn't an SSI issue, it's a Medicaid issue, so I'll do it when we get to the bottom half. But people have put their holiday gifts, they put their birthday gifts, they put all this stuff into an account for their child, in their child's name, saving up for their child. Well, now that child's got $5,000 and they can only have $2,000, right? So that's something you want to be looking at and monitoring as your child is growing up and finding a different way to be saving for them. You can save in an ABLE account, you could save you could have a separate, I've told people this to me makes a lot of sense, have a separate brokerage account that you know is for your child and have the beneficiary of that brokerage account when you pass away be your child's special needs trust. You're managing it, it's totally revocable. If you want to pull money out, you can do whatever you need to manage the money. And then upon your passing, it goes directly to a trust for your child. I think that makes a lot of good sense too. So there are a lot of options, but you want to be looking as the child's approaching 18, make sure that they are not over that 2,000. And again, for Medicaid, right? We're looking at this, and this is what I just had someone run into an issue with. So depending on your Medicaid program, right? We have Husky A, we have Husky B, we have Husky C, we have Husky D. I had a young man in his 20s. He had been on Husky D, right? And Husky D has no asset test. So he was on Husky D, rolling along, no problem. His parents retired. He got on SSDI. And then 2 years later, he got Medicare, I apologize. If you were on Medicare, you no longer qualify for Husky D. You have to move to Husky C. Husky C has a $1,600 asset limit. So the parents come in, they say, we don't know what's going on. Our son has been on Medicaid, he's been on the Husky program, he's on the autism waiver list, and he's almost to the top. Can you believe it? They have a 100-year waiting list right now. And he's almost to the top of the autism waiting list. And all of a sudden, he's not eligible anymore. We don't know what happened. So we dug in a little bit, realized that the state had flipped him to Husky C, which has this asset test. And we said, he has over $1,600. No. His bank account has $1,000. Yeah, but you bought him savings bonds when he was born. And he's had them in his name his whole life. And the parents were very frustrated. They said, what do you mean? No one ever cared about them before. Right, well, you're on a new program now. He can't have those anymore. So we had to work on ways to move that money out of his name. We spent some on his, for his benefit, had him pay some bills for himself, had him buy some new technology. and we were able to do that. So, but it was something that really took this family by surprise, because this Medicaid program now had an asset test, which they weren't accustomed to. So you want to be watching those $2,000, that $1,600 limit, and you want to be keeping an eye on it as your child is maturing and as they're growing older, because it could impact their ability to get benefits. And the Medicaid benefits can be huge, right? It can be someone coming into your home to help you get ready for your day. It can be a work program. It could be helping support you in a group home for living. I mean, there's really a lot involved in the Medicaid program and a lot of benefits that are available through it. So you want to make sure that you're not messing that up. Okay, ready for the next one. So SSI is the least desirable. It is the consolation prize of the benefit, of the financial benefits. And there's a reason for that. SSDI has none of these rules. SSDI, you get more money and you don't have rules, right? I mean, what's better than that? Money and no rules. That's what we like. This is less money and more rules. So it is a kind of a pain in the neck, and you have to be very careful if you have SSI. So SSI would be you're 18 years old, you have low income or no income, and then you have low assets. So that $783 a month that we talked about is supposed to cover all of your expenses. If there are other people contributing to your expenses, they take your money back, right? You don't get the money because you don't need it all, clearly, if someone else is helping. So, and my husband has decided to wash the window outside where I am, even though I told him I was on a webinar. Perfect. So this is what's called in-kind support and maintenance. That is if you receive something, right? You receive food or shelter specifically. You're living at mom and dad's house and you are not paying rent. This is the big thing. People come in and they say, my child's not getting the whole $783. This is why, because they live at home and they're not paying rent. So it's reduced. The nice thing is that it's only reduced by 1/3 of the total benefit. So this is a decision we make a lot as a trustee. So if we have a trust, the trust is fairly significant in size. We might say, you know what, the trust will pay for the person's food and lodging. And we know that it's going to take a hit of 1/3, but it's worth it because there's enough money in the trust to do that. And we're not concerned. We have other clients that have trusts that are much smaller and more modest. We don't want to take that hit of 1/3. We want to stretch it. So it's something to be aware of. Sometimes the calculated decision is to take that 1/3 hit. And then there's deemed income. So that could be someone else's, your parents. Like I said, if you're under 18, you probably won't qualify. If your spouse has income, you probably won't qualify. We can flip. And then the other thing that it doesn't say on that slide, and I thought it might, so that's why I wanted to flip, but is that any cash that goes to someone SSI reduces $1 for dollar. So this is one of those places that being in Connecticut actually can be an advantage. So in this scenario, we're going to talk a little bit about if you were in another state, you would have some real issues. And I'm going to change the number on this to 803, if we can imagine. So this is an illustration of planning with SSI. So the parents want to help their child with disabilities live a better quality of life. What can they do? They want to give the child, and I'm going to, for ease of math, change it to $803 of additional support to their daughter with disabilities, right? So we can flip. Thank you. So if the parents give the daughter $803, right, they think, what I'm doing, I'm giving it to my daughter. I want her to make her own decisions. I want her to pay her own bills, all really valid things for a parent to want to do, right? I want her to learn how to use a checkbook. People still use checkbooks. My kids sure don't. So, you know, we want to make sure that she can do all these things. So they give her $803 a month. Well, you know what they do? You know what happens to SSI? Gone. Right? It gets decreased. The first 20 is allowed, right? Which is why I made it 803. And then the SSI is reduced dollar for dollar. So they get no SSI. So you just totally replaced the SSI payment with the $803. And if you live in a state where your Medicaid is dependent on being eligible for SSI, not only did you just lose your SSI, you also lost your Medicaid. So that's one of the reasons I don't mind the Connecticut system, even though it's a little more hassle, because boy, there's a lot at risk with that. Okay, but instead, if they give the money directly to the landlord, they only lose that third, right? Because they didn't give the money to her. So that's similar to if your child lived at your house and you were paying for their food and lodging. So this is a much better result. And this is a result as a trustee that we sometimes make this decision. You know, we'll lose that third. It's worth it to have the person in a safer place where they're more comfortable and they have a better quality of life. And then we can switch to the next one. Here are some of the things that are the things that count, that would count for that third reduction, right? So if you pay for any of these things, the actual value will be added up, and in the most the person can lose is a third of their SSI. Food, mortgage, real property, fuel. So it's all things that have to do with food and lodging. So what's not there, right? Clothes, cell phone, right? Travel. So when I have someone like, you know, like I do have that client with the smaller trust that's on SSI, we pay for those things. We pay for what they need at Home Depot. We pay for the insurance for their car, right? Those things that are not part of this because they're not going to reduce their SSI. Okay, we can flip. So this is the other option, right? We have the money is in the special needs trust, and the special needs trust, instead of paying for the food and lodging, paying for other things that are not on that list. We're paying for their cable bill, we're paying for them, they need a new phone, their refrigerator broke, we bought them a new fridge, those kind of things, right? They're not on that food and lodging, so they don't impact that, and we can still improve their quality of life. So that's the math we do as a trustee, and that's the math you would want someone to be able to do if they were your trustee. All right, next please. I know we're getting close here, so I will just kind of talk generally about trusts. Special needs trusts. So if you're worried about that $1,600 maximum and the $2,000 maximum, what can you do with funds that are over that? And what do you do when you want to improve the life of a person when you're gone? So we would suggest that you wanted to be using a special needs trust. Money held in a special needs trust does not count as their money. You have a trustee that's in charge of the money, and the trustee has sole and absolute discretion. So it's not the person with a disability's money, and it does not count against them. Okay. So here's just a little bit, right, that if you are losing your SSI or you decide not to apply, like I said, I have families that say we have plenty of money, we don't need to apply. This is approximately what you could be losing, $850,000 a year. And then the Medicaid waiver programs, forget it how much their value is. Not to mention the fact that sometimes there's no other provider, right? I mean, before Affordable Care Act, there just was no other person that would insure people, right, if you didn't have Medicaid. And then, you know, as far as a lot of the group living and things like that, sometimes there are no other providers other than Medicaid. So even if you can afford other providers, sometimes they just don't even exist. Okay, I'm going to try to, I was going to try to zoom through, but I guess we did. So let me just check the question and answer. So we didn't really discuss special needs trust, able accounts, all of that. That's not really what we were focused on today. We were more focused on being prepared for that change of 18, what your benefits could be, what kind of things to be watching out for issue spotting, and then about the substitute decision making. So those were really our focuses today. I have been down to speak to your group before, really specifically on special needs trusts and how they all work, first party, third party, able accounts, all that stuff. I'm happy to do that again if anyone wants to at some point, but this was not the focus today. So I apologize if that's kind of, you know, if you were wanting more information on that. I'm gonna look in the Q&A box. I think I answered the question about my husband is 65. Is my son entitled to any of his Social Security? Once your husband starts collecting his Social Security, your son will. If your son has a diagnosed disability from before he was 22 years old, and he is not earning substantial gainful, he's not doing substantial gainful activity, which this year is about $12,000 a year. So there are some hoops but he could be. What kind of disability do they have to have? So typically the disability, we use the Social Security definition, which is they have to have a disability. So it's based on work that keeps them from working, and they're not going to be able to work for at least 12 months. So I have clients that use wheelchairs. I have clients that have cerebral palsy. I have clients with all kinds of what we would in lay terms call disabilities that are not considered to have disabilities by Social Security because they work. So it's really based on a profile of can they work, can they earn more than the substantial gainful employment line, which like I said is about $12,000 a year. And if they can't work, is it going to last more than 12 months? So it's really, it's really based on ability to work. If a child is 16 and has an inherited IRA, whoops, should it be switched within a certain time span before they're 18? That we'd have to have much more detailed discussion. IRAs have just had a big change this year too. IRAs now, if they're inherited by anyone other than a spouse or a person with a disability, have to be taken within 10 years or 5 years potentially. People don't get the stretch anymore. It's really something you have to talk to a financial person about. How far back do they look at an 18-year-old's savings when determining eligibility? I don't see them looking back at all, right? I mean, we don't want to have been giving gifts, so you want to move things out within 5 years, but I don't see a look back issue typically. Is there somewhere we could see your past talks and special needs trusts? You can look, so I am at Sapega Daily Pope and Perry. Our website has a ton of stuff, and during the pandemic, since we've switched to this webinar format, we've been recording our webinars. So I have other webinars that you could be able to pull up at the Sapega Daily Pope and Perry website. Or if there's something specific you have a question about, you could either email me, or our marketing guy is Kevin at ctseniorlaw.com, and he has everything. And my email is Colleen at ctseniorlaw.com if you want to reach out to me with a specific question. All right, I think we've hit most everything. Is there anything else that the panelists would like me to hit or make sure that we've discussed?
Are there any more questions? I can't really tell.
There's nothing else in the question and
All
answer.
All right.
Yep.
There was a question. I don't know if she ever actually typed it into the Q&A. Let's see what the question was in the chat.
There's a bunch on the chat.
Oh, the 1/3 reduction. We did talk about the 1/3 reduction. Yeah. So
Great.
I think that we're, so I think we're okay there.
This has been great. We could sit and listen to you for hours and hours and learn something new each time.
That's terrifying.
It's a lot of great information.
Yeah, no, it's a lot of information, but it's incredibly important information.
Yeah, and it does get dense, so I apologize for that. So like I said, reach out if you have a specific question. Okay.
Just so everybody knows about everything, the video and the PowerPoint will be on our website and also on our Facebook page.
Super. Thanks so much.
Okay.
Yeah, thank you so much.
Thank you so much.
All right. Thanks, everybody. Have a good day. Enjoy the heat.
Thank you.
Bye.
Bye.